9 seconds. That's how long the courtroom stayed completely silent after the audio cut out. Not because the recording had finished. It hadn't. The prosecutor had paused it deliberately to let the jury look at the defendant's face. What happened in that federal courtroom in Washington on Monday isn't a political story. It stopped being political the moment a sitting cabinet secretary handed investigators 11 encrypted files, signed a cooperation agreement on page 3, and walked into a grand jury room for 6 hours. This is a legal story now, a documentary record, and that record is more damning than anything the headlines are capturing. I've been through the filings, all 94 pages, dropped Friday at 11:47 p.m., the exhibits, the forensic certification, the sealed attachment summary. Here's what the documents actually say, and what they reveal that almost nobody is talking about. Rewind. March 4th. A subpoena arrived at a private law office in Northern Virginia. The recipient wasn't a low-level staffer, wasn't a former campaign aide, wasn't someone operating at the margins of the administration. It was the sitting Secretary of the Treasury. The subpoena, filed under case number 1-26-OR-00214 RBW in the U.S. District Court for the District of Columbia, requested all internal communications related to a specific series of wire transfers, $6.2 million, routed through 3 entities registered in South Dakota, Montana, and the U.S. Virgin Islands between August 2024 and January 2025. The Secretary's legal team had 21 days to respond. They responded in 4. Not with documents, not with objections, with a phone call to the Office of Special Counsel. They said they had materials the government hadn't asked for. Materials the government didn't know existed. That's where this case broke open. Escalation. What the filing actually says. Here's what the 94-page filing establishes. Not alleges, establishes, through authenticated documentary evidence. The wire transfers weren't campaign finance violations in the conventional sense. That framing is too narrow. According to page 17 of the filing, prosecutors have classified this as a coordinated federal funds misappropriation scheme, meaning money that moved through federal contractor accounts, not just private shell companies. That distinction matters enormously. Why? Because it triggers a completely different set of statutes. Not campaign finance law, not the Federal Election Campaign Act. Title 18, United States Code, Section 666, Federal Program Fraud, and Section 1343, Wire Fraud. Both carry 20-year maximums. Both apply to every individual in the chain who had knowledge of the routing. The filing names 7 individuals as unindicted co-conspirators. Their names are currently redacted, listed only as CC1 through CC7. But on page 29, prosecutors include this. Several unindicted co-conspirators held, at the time of the conduct described herein, positions requiring Senate confirmation. Senate confirmed officials. That's the tell. That sentence was placed there intentionally. Prosecutors don't include that kind of descriptor by accident. They're signaling the scope of what's coming. The recordings now, here's what the Secretary of the Treasury's legal team brought to the special counsel's office. 11 audio files, recorded between September 2024 and February 2025, on a device issued by the federal government, stored on a server with automatic timestamping through a secure federal archiving system. Page 44 of the filing describes the authentication process. A forensic examiner, 19 years with the FBI's Operational Technology Division, now in private practice, analyzed every file. His certification appears on page 61. Direct quote. Each of the 11 files bears metadata consistent with the recording device's serial number, the federal server's authentication log, and the stated dates and times. No evidence of manipulation, splicing, or post-production alteration was detected in any file. Not allegedly recorded. Not purportedly authentic. Forensically certified. By a former federal examiner whose methodology is documented across 4 pages of technical appendix. The defense has already signaled their response. They're not challenging the forensics. They're going after the circumstances, specifically whether recording a superior officer during confidential policy discussions constitutes an unauthorized interception under the Electronic Communications Privacy Act. That argument appears in the emergency motion filed Monday at 6:23 p.m., case docket entry 47. Here's the problem with that argument. Federal courts have consistently held, and the D.C. Circuit reaffirmed this as recently as 2021, that one-party consent applies to participants in a conversation. The person holding the device was a participant in every one of those 11 calls. That door is already closed. What the transcripts show 3 of the 11 calls have been partially unsealed. The transcripts are attached as Exhibit F. Call 2, October 9, 2024, 4:47 p.m. The subject of the call, according to the header, was described internally as a budget reconciliation discussion. What the transcript actually shows is something different. A voice identified through voice pattern analysis, documented on page 58, as consistent with the primary defendant directs the secretary to, quote, make sure the oversight window stays closed until after November 1. The secretary responds, I'm not sure that's something my office can do unilaterally. The response, you're not doing it unilaterally, I'm telling you to do it. Call 6, December 3, 2024, 2:11 p.m. The primary defendant references a specific transfer amount, $840,000, and instructs the secretary that a particular contractor account, quote, doesn't need to be part of the quarterly report. That figure, $840,000, appears independently on page 72 of the filing, in a separate section describing wire transfers the grand jury has already traced. That's not a coincidence. That's corroboration. Call 9, February 17, 2025. The transcript is the shortest of the 3, 41 seconds. The primary defendant says, this stays internal, no paper. You understand me? The secretary says, yes. Then the line goes quiet for 9 seconds. The courtroom moment Monday afternoon. The prosecutor played call 6 in open court, 37 seconds of audio. When it ended, she didn't speak immediately. She let the silence hold. 9 seconds. Then she pressed pause and turned to face the defense table. Trump's legal team, this case involves a former senior official in the Trump administration, let's be precise about that, filed an immediate objection. Privilege, Article 2 authority, executive deliberation. The judge overruled it in 11 words. The crime-fraud exception has been established to this court's satisfaction. That ruling, issued verbally from the bench at 3:22 p.m. and entered into the written record at 4:09 p.m., is the most important single sentence in this case so far. The crime-fraud exception voids executive privilege claims when the communication at issue was made in furtherance of a crime. The judge didn't say this evidence might fall under that exception. Didn't say prosecutors had made a preliminary showing. Said the exception has been established. Past tense, concluded, done. The counterargument, and why it's not nothing. Here's where intellectual honesty requires a pause. The defense arguments aren't frivolous. Some of them are serious. First, the recordings. A cabinet official secretly recording a superior officer, even a constitutionally constrained one, is not a neutral act. It's a choice, and the timing of that choice matters. The secretary began recording in September 2024. The subpoena didn't arrive until March 2026. 18 months elapsed between the first recording and any formal legal cooperation. If the conduct on those recordings was criminal in September 2024, why did the secretary continue serving? Why not resign immediately? Why not report to the inspector general? Why not go to Congress? The defense will make this argument at trial. They'll call it opportunism dressed up as whistleblowing. They'll say the recordings weren't made out of civic duty. They were made as insurance, a safety net for someone who had their own exposure and needed leverage. That framing isn't invented. It's documented. Look at page 14 of the immunity agreement. The grant of immunity is described as comprehensive, covering conduct during the entirety of the secretary's tenure, not just the cooperation going forward. That means prosecutors believe the secretary had independent legal exposure, real exposure, enough that it required protection before cooperation could begin. Not a minor footnote, not a procedural formality, a full immunity grant covering everything. The defense will put that on a board in front of the jury. Second, the language in the transcripts. Make sure the oversight window stays closed. Is that obstruction? Or is it a principal officer directing a subordinate on a legitimate administrative timeline? Doesn't need to be part of the quarterly report, criminal concealment, or a judgment call about report scope. Courts have drawn this line differently in different jurisdictions. Constitutional scholars have flagged the genuine ambiguity, not as apologists, as lawyers reading the actual text. Here's the response to that argument, and it's decisive. Call 9, 41 seconds, no paper, you understand me? That's not an administrative instruction. That's not a policy preference. Directing a subordinate to generate no documentary record of a conversation that concerns federal funds is, on its face, evidence of consciousness of guilt. That's the one the jury will hear last. The expanding scope. Here's what most coverage missed entirely. The immunity agreement isn't the only cooperation development. On page 81 of Friday's filing, prosecutors include this. The government has received proffer communications from counsel representing 3 additional individuals whose identities remain under seal pending judicial authorization for disclosure. 3 more, unnamed, under seal, and on page 83, at least one of the sealed cooperating witnesses held a position described in Section 2 of this filing. Section 2 of the filing describes individuals who held Senate-confirmed positions. That means at least one additional Senate-confirmed official is cooperating, beyond the secretary, beyond the 7 unnamed co-conspirators. The prosecution isn't building toward a single witness. They're building a structure, multiple corroborating voices, each with independent documentary support, each describing the same pattern of conduct from a different vantage point inside the same administration. That's not a case. That's architecture. The witness intimidation question. Within 3 hours of Monday's hearing adjourning, public statements appeared online referring to the cooperating witness as a traitor, questioning the secretary's mental stability, and calling the recordings fabricated, despite the forensic certification entered into evidence that same afternoon. The special counsel's office filed a motion Tuesday morning at 8:51 a.m. The motion, docket entry 52, requests a judicial order prohibiting extrajudicial statements that could prejudice ongoing witness cooperation. The judge hasn't ruled yet. But the motion itself is now part of the record, and every public statement made after Monday's hearing is being logged. The empathy bridge. Here's why this matters to you directly, not as a political abstraction, but as a practical reality. The $6.2 million at the center of this case moved through federal contractor accounts. Those accounts are funded by the federal budget. The federal budget is funded by tax revenue, your tax revenue. The allegation, documented, not asserted, is that money appropriated by Congress for specific federal programs was redirected through a series of intermediary entities for purposes that prosecutors have described on page 19 as inconsistent with the statutory authorization for those funds. This isn't about partisan politics. It's about whether federal money went where Congress said it was supposed to go. If it didn't, that's not a campaign finance violation. That's theft from a public account. And the question of who authorized it, who knew, and who was directed to keep it off the quarterly reports, that's what the next phase of this trial will determine. The 3 tracks converging right now, 3 parallel legal tracks are moving toward a single decision point. Track 1, the primary criminal case, trial currently scheduled for September 14th. With 3 additional sealed cooperators and expanding documentary evidence, expect the defense to push for a continuance. If the judge grants it, this moves into late 2026. If she doesn't, both sides go to trial, with evidence still being disclosed in real time. That's chaotic. And chaos tends to benefit whoever has more documents. Track 2, the executive privilege appeals. The defense has already indicated they'll appeal Monday's ruling on the crime-fraud exception to the D.C. Circuit. That appeal could pause certain proceedings, but here's the constraint. The forensic evidence, the wire transfer records, the independently corroborated financial documentation, none of that is covered by any privilege claim. The appeal only touches the recorded conversations. And prosecutors have built a case that doesn't require the recordings to survive an appeal. Not X, not Y, Z. The recordings are powerful. The privilege fight is real. But the wire transfer trail is self-contained, independently documented, and privilege-proof. Track 3, the sealed cooperators. The judge has set a disclosure deadline for July 11th. That's when we find out who else is cooperating and what they've provided. If any of the 3 sealed witnesses have their own recordings, their own documentary evidence, The defense's entire strategy has to be rebuilt from scratch in the middle of trial preparation. July 11th is 26 days away. Where it stands: 11 audio recordings, forensically certified on page 61. All privilege challenges overruled. 3 transcripts partially unsealed. 2 more call references corroborated by independent wire transfer records. Full immunity granted to the Secretary of the Treasury, comprehensive, covering the entire tenure, which means prosecutors documented real exposure before offering protection. 3 additional sealed cooperators. At least 1 Senate confirmed. Disclosure deadline, July 11th. Emergency motion on extrajudicial statements pending before the judge. Every public statement since Monday is in the record. Trial date, September 14th. Defense continuance motion expected. The forensic defense, fabrication, manipulation, AI generation is gone. Page 61 closed that door. The privilege defense took a severe blow Monday at 3:22 p.m. The D.C. Circuit appeal is coming. It may not matter. The only remaining questions worth watching: what do the sealed cooperators have? What does the July 11th disclosure show? And when the defense finally sees the complete production from the cooperating witnesses, all the documents, all the communications, all the financial records, what contradicts what they've already said publicly? That production deadline is Wednesday. Close you. Here's what I'm watching most closely between now and July 11th. The language on page 83. At least one of the sealed cooperating witnesses held a position described in Section 2, is doing a lot of work. Senate-confirmed officials don't cooperate quietly, they negotiate, they provide, and what they provide tends to be institutional, not just memories of conversations, but records, internal communications, decision logs. If one of those sealed witnesses was inside the room where the $6.2 million routing was discussed and documented, the trial doesn't look like a contest anymore. It looks like a closing argument waiting for a verdict. But we don't know that yet. What we know is what's in the filing. 94 pages. Time-stamped, certified, entered into the record of a federal court. The next document drops Wednesday at midnight. When it does, I'll be going through every page. Don't miss it.